people have looked at people with disabilities and people in institutions and nursing homes and have asked me, why do we have to give them special rights? And we find that it's not special rights. It's civil rights. Rights that they should have had all along.
And do have, but were not acknowledged and are now not being implemented. I agree.
Tell me a little of how you became involved with Lois and Elaine.
Lois was a person who'd been in and out of the state hospital in Georgia, probably, I think in her case, about 20 some times. She was labeled developmentally disabled, and she was labeled mentally ill. When I knew her, she had been, in my judgment, she had been somewhat abandoned by the system, meaning she'd been in the community a few times, she'd been in and out, and she'd ended up in this place where, when as her legal advocate I would try to get her out, the answer would be, in effect, we give up. We're not going to bother. She's just going to stay here. We don't think that she's going to make it in the community. And Lois, at the time that the case was filed, for say that 2 or 3 years before that, had become very resigned almost. She was 20. I think she was in her late teens, early 20s. She'd almost just given up. She'd been in and out of institutions since she was 14. So anyway, but one of the true giants of the disability rights movement we all know, whose name is Steve Gold, he's a lawyer in Philadelphia. He had successfully litigated a case on behalf of a person in a nursing home, and that court in Philadelphia had said that that nursing home resident had a civil right to receive her Medicaid services in the community. So because that was a new case, we thought about applying that principle to Lois Curtis, and we filed a case in federal court relying almost very much dependent on the Third Circuit case of Steve Gold. I guess I'm bringing that up saying because if it had not been for that case, it's this amazing combination of things, right? The wonderful Lois, our frustration that we felt like we tried everything, Steve Gold's case, everybody being so annoyed at the state hospital for not caring about Lois, and her courage, all of that together, we decided to try the ADA theory for Lois in federal court. And how I got involved is just because I was running this project at Langley Glade, and we were representing a lot of people at the institution at that time. And then Elaine Wilson, the other plaintiff, she came along a few weeks later. They were going to throw her out of the state hospital because she'd been institutionalized there, I think, 38 times, if I remember. That might not be even more times than Lois. But instead of just confining her there indefinitely, which seemed to be what the plan was for Lois, in Elaine's case, they were going to throw her into a homeless shelter. So we opened a file for her at Atlanta Legal Aid, and we objected to her discharge to a homeless shelter, and we were able to prevent that, and then we decided to join her. She joined the case later, I think about 3 or 4 months later. Because her problem was the same. She could get out, but only if she were to live in a homeless shelter.
But could she receive services in the homeless shelter?
No, because before Olmstead, right, the legal theories were limited. to two kinds of arguments. You could argue that the person didn't meet the criteria for inpatient confinement. This is talking about state psychiatric situation. That, in other words, as most people would understand the concept, if you're not dangerous to yourself or to another person. So you could argue that as a legal advocate and successfully get your person out, but you had no legal principle to apply to make sure that person got the services she needed. Or you could argue, and that would have applied to Elaine, right, if we didn't try the ADA argument. We could have gotten her out. In fact, the state was trying to throw her out. The other argument is called the right to appropriate treatment argument, which was the more conventional one we used to try. Would have applied better perhaps to Lois. Because of her label of mental retardation, she was obviously not getting any of the services she needed in a state psychiatric hospital. So we could have argued for Lois that, all right, if you're going to keep her there forever, you could at least provide her with the services she needs. Well, interestingly, from the point of view of a person with a disability, of course, you don't want to be stuck in a segregated situation, even if you do get services, and you don't want to be dumped out into a homeless shelter or to some other inadequate alternative. So the ADA theory applied perfectly because it requires that the state have the affirmative obligation to provide the services in the more integrated setting. And that, again, finally getting around to it, but I'd say that's the biggest step forward. And it is a civil right under the ADA that the Olmstead decision established. That the state not only can't lock you up when you're not dangerous to yourself or others, but it also has an obligation to provide appropriate community-based services.